Is an employer bank liable to the victims of a fraud perpetrated by his employee? To find out, you have to read the More Charitable Foundation versus PJT, but it's 29 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, New York Court of Appeals cases that I try to cover in 5 minutes or less. This is going to be a challenge. It's a little fact-heavy and intense in this case. This is the episode of the case of More Charitable Foundation versus PJT. It can be found at 2023 New York Slip Opinion 03185, published by the New York Court of Appeals on June 13th of 2023. The issue in this case is what legally sufficient means with respect to a claim of negligent retention and supervision. I'll explain all that in a few seconds. What you have to understand to appreciate what's going on here is two different aspects of the law. First is a claim, a motion to dismiss based upon failure to state a cause of action. This can be found at CPLR, the Civil Practice Law and Rules, CPLR 3211. There's a motion to dismiss a case based upon failure to state a cause of action, which basically means even if you assume every single allegation in the complaint is correct, the defendant is still not liable. That's what that claim is. The second thing you have to understand is what negligence and a claim of negligent retention and supervision is. Negligence, to be overly simplistic, is a tort. It's a civil wrong with 4 elements: duty, breach, causation, and damages. But a claim of negligent retention and supervision is essentially a claim that the employer of an employee committed an offense against you, a tort against you, by failing to properly rein in the employee. There's some elements of that as well. The employer had actual or constructive knowledge of the employee's propensity to commit the tort, the behavior that caused the injury. Number 2, the employer knew or should have known that it had the ability to control the employee and the necessity and opportunity to do so. And third, that the employee engaged in tortious conduct in a civil wrong on the employer's premises, or using the employer's property or resources or confidential information. That's the claim. That's the tort of negligent retention and supervision. So what are the facts here? The facts are that there's a banking institution, a investment banking firm called PJT. That's the defendant in this case. PJT hired Casperson as its employee. Casperson was a productive, high-ranking employee in this firm. And Casperson had some issues. Casperson would come to work after having 1 or 2 Bloody Marys throughout the day, would drink maybe 10 to 15 more alcoholic drinks, would day trade maybe compulsively or obsessively with his own personal money, would go to meetings, sometimes inebriated with clients. That's Casperson. But Casperson was also very productive. Casperson, who was given a lot of authority and had the authority from the employer to use company email, to conduct business, to negotiate deals, Casperson arranged in 2014 a deal that was worth $500 million and yielded the firm, PJT, an $8.1 million fee. That's great. But instead of giving the client the wiring instructions to send the money to the firm, he gave them wiring instructions to send him the money. So now he's embezzling. He's stealing money from the firm, $8.1 million. He promptly day trades it away, so he doesn't have the money. A month later, the firm says to Casperson, hey, where's the money? Where's the $8.1 million fee we earned? And he says, well, we're waiting for the stub fee. We're waiting for the last transaction, and then we'll get the fee from the client. But Casperson knows that he's going to have to come up with that money. So he calls his college friend, who runs the More Charitable Trust, the More Charitable Foundation. And that's the plaintiff in this case. And he says, hey, I've got a 0 risk opportunity. You make 15% back. We just need a lot of money from you. And the More Charitable Foundation, communicating with Casperson via the company email and on company phones, and after getting official confidential financial information on this fake deal, sends $25 million theoretically to PJT. But Casperson, once again, gives him a fake routing number to send the money to Casperson, who then pays back the $8.1 million he owes, and then day trades the rest and loses $14 million of the money. Obviously, Casperson is committing crimes, and he winds up going to jail, to prison for 4 years on federal securities and mail fraud claims. But remember, the More Charitable Trust is out $25 million. So they sue PJT and say, you are responsible for that loss because you negligently retained and supervised Casperson. They make a motion to dismiss on that CPLR 3211 saying, even if what you're saying is true, we're not responsible because we had no idea of his propensity to commit fraud. The trial court agrees and and it dismisses it. It goes to the Appellate Division and they say the trial court was right. But more than that, you were never a client. The More Charitable Foundation was never a client of PJT. So there was no duty. And now it goes to the Court of Appeals. And we now have a majority and a dissent. And the majority opinion says that they are responsible, theoretically, that on this motion to dismiss based upon failure to state a cause of action, the allegations as alleged, these allegations are sufficient to make out a claim of negligent retention and supervision. Why? Because the employer should have known that the propensity to commit fraud was there when he said that stub fee thing. When Casperson told the back office, I know this $8.1 million is missing, but you'll get it at the end of the stub fee, at the end of the series of transactions. That was transparently false. And at that moment, the employer was on notice that Casperson could be committing fraud here. And secondly, as to the duty argument, they say there's no requirement that there be a client relationship, a client-firm relationship, a special relationship, we call that, for there to be a negligent retention or supervision claim. The majority says that's not required. All that's required is that harm result as a result of the employee-employer relationship, and the employer is on notice of it. If the employer is on notice of the potential for this tort to be committed, and the tort's committed, and the plaintiff is injured as a result, that's the liability. There's no requirement of privity or contractual relationship between the victim and the employer. Now, there's a dissent here. There's a dissent opinion here by Judge Singas, and she says this is totally wrong, and we're opening up liability, unlimited liability, to anyone who goes into their employer's office and starts making prank phone calls. And also, she warns, this opens up New York as a policy matter to losing a lot of business because people come to New York. It's a financial center of the United States because of our secure, predictable jurisprudence on negligent retention and negligence in general and commercial transactions generally. And here, the majority is going beyond what the statute and beyond what precedent says and opening up New York to a lot of liability. So that's the case of the More Charitable Foundation versus PJT. Fascinating case and talks about legal sufficiency and negligent retention and supervision claims. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.